Just waiting for the rest of the committee to come in.
Hey, Roxana, they should be jumping on momentarily.
They should be on here momentarily.
Yeah. Okay, that's.
Hello.
Hello.
Sorry I was late. Have we started the meeting? I don't hear anything.
Yes, yeah, we're waiting for one more member.
Yeah, we're just waiting for the third member. She should be jumping on momentarily.
Sorry about the confusion. I just there were so many emails floating around, and as of yesterday, I had nothing on my calendar.
No worries, no worries.
Okay. And so next week's still on for next Thursday.
That's correct.
Yes,
Okay. I'm giving up a golf game, so I want to make sure we have it.
yes, it's still active.
All right, we all set. Roxana? It's all yours.
Ready?
Yeah, it's all yours. All three is there. I guess we'll start with the first one that came in and we can move on from there.
Okay. First, we need to call the meeting to order. So it is now 3:14. We're calling the meeting to order. Committee, I would like to manage the meeting if you give me permission. Hello?
You need somebody to make a motion, I'll make that motion.
Yeah, I just had one of the committees drop off though.
Yeah, they'll pop back on. And you just need another motion from the second one. The second motion. EBC, can you second?
I can second.
Okay, we
Thank
okay, we're just
you.
waiting. Thank you. So we're just waiting for the third committee member to pop back on. She probably had difficulty. I seen her pop on and just went off and just give her a couple of minutes to pop right back on. But in the meantime, Roxana, you can do the laundry and the etiquette, so we can have the etiquette for the committee, so they know what to expect for this hearing.
Okay. So I'm going to establish a quorum once the third committee member pops up. Proof of notice was served on time. This was a rescheduled meeting from May 28th to today. We're going to be going over the old businesses, which is ratification of the meeting minutes previously had of all the other committee meetings that we've had. They have to be approved by the funding committee. So we would just make a motion and I would need a first and a second. And then we'll move on to the new business of the new violations that we have for today. However, we are still missing the third committee.
Yes, just to further reiterate that this meeting is of the finding committee. This in regards to only the fines and the fines that are before the committee. Nothing else will be discussed in this meeting regarding that. Other than that, the floor is open to only the owners that are defending their cases. And you know, we just want to exercise that etiquette. Roxana, you can also disable that chat.
It's been disabled.
Okay, thank you.
So now I do want to establish a quorum. We have all three committee members present.
Okay, do you need me ready to present?
I'm going to make a motion to ratify all the old committee meeting minutes
I'll second that
for
motion.
August 21st, October 2025, November 2025, December 25, January, February, March, and April 2026.
I second that.
All in favor?
Aye.
Aye. Thank you. Okay. Now, Gerard, if you would like to present the first case, we do have an owner on site and on the property.
Okay, this in regard to which number?
Unit 523, correct?
Oh.
523, Mr. Gambino? Mr. Gambino? 523, correct? Okay, yes, unit 523. So just so
Okay.
you're aware, the association is going to present their case, and then you're going to be able to stand up to the podium and present your side of the case so the finding committee can hear both sides. Okay, go ahead, Gerard.
Okay, this is in regard to the leasing violation. So the board of directors decided to issue a total of 3 violations for, the first one is for late lease submission. The second one is for occupancy for remaining on the property. And the third one is for the owner not failing to remove the tenant off the property. So let me just start off with the first violation. First violation is in regards to, let me just read into the record, the letter that was sent to the owner in regards to this. So this is in regards to, the association is in receipt of your application to renew the lease for the above mentioned unit dated March 28, 2026. The association board of directors at a duly noticed meeting on April 27th, 2026 voted to deny the application. As such, the lease may not proceed and all occupants must vacate the unit no later than May 4th, 2026. The denial is in regards to the prospective lease or any other proposed occupant have during previous occupancy evidence and attitude of disregard for the association. The owner failed to give proper notice to the association of the intention to lease the unit or renewal in this case. And so, and also too, this is also the owner receives the lease renewal reminders from the association automatically 30 days and 60 days in advance to ensure that they are properly informed. The unit lease expired on March 31st, 2026. However, the renewal application was not submitted until March 28th, 2026. And additionally, the owner and tenant has engaged in violations. The first violation occurred on 3/28/26. This is late lease submission. One prior to that was another late submission, which was on 3/30/25. And the other one prior to that was a late lease submission that occurred on 4/12/24. All of these were submitted late and prior to. We tried to work with the owner regarding this. So the first one, they did not receive a violation, but the second one they did. And then subsequently, the third one, they did receive a violation, which is before the committee at this time. This letter was sent to them and they were supposed to remove the tenant out by, and the unit, just in regards to unit 523, but they were supposed to remove the tenant by May 4th, 2026. Access to the property was shut off for the tenant, but the owner then put access onto the tenant through his access. It has been properly monitored by the association through the electronics of the association, meaning the surveillance system and the getting into the property with the either the card or the app. He then subsequently received another notice after not having the tenant vacated. We had the association attorney send a certified return mail and email letter to to the owner in regards to the same thing with the lease violation. Just going to jot that in right quick to the minutes. Says, as you're aware, the association has denied the application to renew Mr. Owens' lease for the unit. The association has association by letter dated April 27th that Mr. Owens was to vacate on May 4th, 2026. A copy of the letter was enclosed for the owner's reference, the one I just read to you guys. The associate has become aware that you have allowed Mr. Owens to continue to occupy the unit despite the association's denial of the application to renew the lease. As such, Mr. Owens' occupancy of the lease is in violation of the association governing documents. So the other statement that the attorney also wrote was, when you purchase a unit, you agree to abide by the comments, conditions, and restrictions contained in the Declaration of the Royal Greens at Gateway. Meaning that when we got our deed is restricted deed to the association. Section 17.8 of the Declaration of the Condominium makes it abundantly clear that all leases must be approved by the association, which is governed by the Board of Directors. The association has previously contacted you regarding the above-mentioned violation and has followed the procedure step to levy fines against you. Fines will continue to occur against the unit until the unapproved tenant is vacates. The association requires that you take the following action. 1, remove the unapproved tenant from the unit within 5 days of the receipt of this letter. Number 2, notify the association within 5 days that you have removed them. And 2, comply with the association leasing restrictions with respect to all future leases. Neither one of those restrictions have been complied with. So as such, the property manager sent the email on May 21st to the owner, Mr. Gambino, and she said in the email, she says, we are writing to you regarding Unit 523, the occupancy status of the unit. Our records indicate that Mr. Owens has been listed as the resident tenant for the unit. Please confirm whether Mr. Owens is still residing in Unit 523 or if he has moved out. If Mr. Owens has vacated the unit, please provide move-out date. Thank you for your prompt petition. We appreciate. The answer Mr. Gambino gave us was that the tenant still is in place. And as of this day of the entries and exits of the property, the tenant is still here. The second violation is basically the same thing, but the only thing is that is for occupancy violation. He is not approved to be here, so he received a violation also for remaining on the property. The owner also confirmed that he remains on the property. He also received another violation for failure to remove the tenant from the property, which at the time the tenant still is here on the property. Those 3 violations were issued by the board of directors, and they are before the committee to this date. Committee, I just want to let you know that this is an ongoing situation, and it hasn't been resolved yet. We're still working with the association attorney in regards to this. It is getting to the point where it's getting a little severe, where it's probably going to be a little more, it's going to be added to it. You know, unfortunately, we all sign we all are owners here, and we all abide by the rules that we signed on to come into this community. The board of directors do not make the rules. We just volunteer to enforce them, among other things. At this time, Mr. Gambino, you can step up to the podium and refute your case.
Hi, I'm Brian Gambino. Please bear with me. I've never been through anything like this. I've owned the unit since 2013. So going on 13 years now. I've had this in regard to this lease. The tenant has been there for 4 leases. This is his 5th consecutive lease with no lapses in tenancy. I am obviously not here to dispute the late lease submission. That's my fault, 100%. I accept responsibility for that. In my defense, I did have it in prior to the due date, so there was no lapse in tenancy even on paper. I offered to actually pay the fine for the late lease on May 5th, 2026. And I was denied that by Mr. Mr. Lewis on May 12th. So I did offer to pay that $1,000 fine on the late lease because I'm actually going up to what I did. I was late. I just think that with the amount of time that I've owned the unit, with the fact that this was a repeat tenant for, again, the 5th term, he's been there four terms. The violations he is talking about, as far as the tenant has been a great tenant. He pays me on time early, which I know doesn't affect any of this, but he had the references items on the lanai, July 10th, 2025, and it says items in the hallway, April 4th, 2023. He has been there since basically 2021, has 2 minor violations out of 5 lease terms. That's less than half a violation a year of very minor things that we can all agree upon. The tenant has already paid 3 months of a 12-month lease. I got notification of the lease denial April 27th after the lease was already in place April 1st. And again, I realized I submitted late, my bad. But he's paid, like I said, 3 of the 12 months. I was asking that the tenant stay in place and I would pay the $1,000 fine because it was my mistake and I was denied that opportunity. And then as far as on the first page of the letter that Gerard or Mr. Lewis was talking about, the owner is delinquent in the payment of assessments for other monetary obligations. I have my fees taken out automatically every month. I'll check my bank account and they have been taken out. I received I have not received a records request for proof of me being delinquent in any assessments. So as far as I know, I'm not delinquent in any assessments or other monetary obligations because they've been coming out of my Chase Bank account monthly for years now. And again, I've owned the unit 13 years and the tenant has been in there 5 leases consecutively. It says also the prospective lessee during previous evidence and attitude of disregard. I would say that having items on your lanai and having items outside your front door are not an attitude of disregard for the association rules. He's been nothing but a respectable tenant. On point 3, I accept 100% responsibility for that. I should not have submitted the lease late. And obviously, if we can come to an agreement on this, you'll never have to worry about a late lease agreement. I'll get to you in January if you want. It's usually due in April. So basically, I'm I have not removed the tenants because he doesn't have anywhere to go at this point. And frankly, he's got a lease in place for 12 months and he's already done a quarter of that lease. So I'm basically offering to pay the $1,000 fine. I think the tenant should be able to stay. He has not shown a disregard for the property. Guy works 2 jobs, he busts his ass like a lot of people do, and to have him basically be evicted, which is what this amounts to, because he had items outside of his door and items on his lanai 2 times out of 5 years. I think that there should be a little leniency there. So I'm just going through my notes here. So anyway, I'd ask you to put yourself in his situation, my situation. I own 1 rental property. I'm not a big landlord. This is a lot of money for me. And I'm willing to, accept that I screwed up on getting a lease in late and I will not do it again. And and again, in 13 years of owning the unit, I've been referenced for 3 late leases, which again is my mistake, but there's never been a lapse in tenancy in the last 5 years. Thanks for the time.
Thank you.
Thank you.
Yeah, I just want to further reiterate for the board of directors is that we didn't come to this decision lightly. At this point, the tenant was legally supposed to remove off the property. We don't make bargains. We don't barter saying if I paid $1,000, the tenant can stay there. The board of directors at a duly noted meeting, which he failed to come in and respond to, made that decision to remove the tenant. He did not come in to refute the reason why we should not remove him. So that decision has already been made. And a word of advice, he's going to continue getting violations, and he's probably going to end up getting a letter from the attorney regarding this, because these rules are made to be here made out of the declaration for this community. There's other communities that are a lot lax and don't have any rules. That is a decision that they can make. But under Roy Green's, we have a responsibility to all owners to enforce the rules and regulations across the board, and we don't barter for that. Further than that, if it just gets.
I received no notice of the lease, and I received no notice by mail or email that this can go on the record of the late lease fine hearing, or else I would have been there and I would have paid it, and this would have been put to bed before it was an issue. Number one, and I have not received that, and again, I have not received a records request for any of this. That should be duly noted as well. And I'm not asking you to barter. I'm asking to pay the initial fine. And if every tenant and every owner is held to the standard, then I'd be interested to know if that is the case. But again, I was not given a notice of that at all via email or mail. I've been very active in trying to get this resolved when I did get the things by email and mail. As you know, Gerard, I was emailing you as soon as I got this stuff. I did not receive the prior things, or else we would have probably gotten this resolved before it came to this point. So I'm again asking for a little leniency. It's not bartering. The initial fine was $1,000. I would gladly pay that because I screwed up. But again, I did not receive the notice for that, or else we wouldn't be probably sitting here right now.
Okay, the reason you are here now is because of that notice. So you did receive it. You did also receive the letter because you responded to the letter. And I said to you, just 1 second, sir. And I said to you that, you have to remove your tenant. You said that you're not removing him. I mean, I don't make the rules, sir. I don't know. I'm trying to work with you, and you just feel that, since he's been here for a long time. And I also reiterated to you that we are not landlords. We are not bound by Florida statutes when it comes to landlords. We are an association. Associations has a duty to the association, not to your tenant. The tenant has a duty to the landlord, and you must comply with that. And just a word of advice, we're way beyond past you just paying $1,000. I'm being honest with you. Once you got that letter from the attorney with the other stuff that wasn't mentioned, Your time was to react then. You still haven't, even to this day, haven't responded to the attorney. So, I mean, you asking for leniency and you asking being responsible, but you have to be responsible and you have to take ownership for what you have done. We way beyond that. Pay $1,000 and have a nice day. We way beyond that. Your tenant has to leave out, and to not accumulate any more violations or fines or even lawsuits, you will have to take an action, sir.
I offered to pay the fine May 5th. I did not get the attorney letter, which I did not know I need to respond to until May 26th, or else I would have responded to that. I responded to the notices from the condo association. And again, I offered to pay this on May 5th, and the attorney letter did not come until 3 weeks later. And I did not know I needed to respond to that because I thought that was going to be resolved this hearing. So if I was unfamiliar with the process, that's my mistake again. But I did this 3 weeks prior to receiving an attorney letter, which I think should also be on the record as well.
Okay, the association board of directors have nothing further.
Okay, committee motion to make the decision within 21 days.
So move.
Thank
Aye.
you. Thank you.
For the record, this committee just decides if a fine should be imposed, if a fine should not be imposed. We don't
Correct.
have the authority to waive any requests the tenant has with the board of directors. Am I thinking about that correctly, Gerard?
That's correct, sir. That's correct.
Okay, I just want to make sure. I mean, I appreciate all the background and all the information, but our decision is just should the fine be imposed or not be imposed, period. That's all we can decide. Correct?
That's correct. That's correct.
Thanks for the clarity.
Thank you. You're all set.
Thank you.
Thank you. 21 days, you'll receive within 21 days, once I make the decision, you'll receive a letter.
21 days, I get a letter.
Within 21 days.
Okay, and then that is. So currently I have 3 violations. How much?
Sir, I'm sorry, I'm still in the middle of the rest of the meeting, so you can send me an email with everything else, but right
Oh,
now,
I can't ask you.
no. So right now, it's just 21 days. Within 21 days, you'll make a decision, you receive a letter.
Within 5 days, I get a letter.
Yes.
Sorry, I don't honestly.
Understood. I understand. No worries. Understood.
Okay.
Thank you. Have a
Can I
good
stay for
day.
the rest of the meeting or?
Yeah, you're more than welcome to. You're an owner. Okay. So next we have unit 203. I believe we have the management company online.
Okay, I have that one. I have that. This is in regards to a violation for a tenant, Mara Villa Rosa, and the owner of PF Carter LLC. And I understand they're being represented by Ms. Karen Hilt, who we had a dialogue with over this violation and why it was issued. So I'm just going to read that into the record. This is in regards to Unit 203, and the violation is for placing a box and some pots inside of the bulk trash. So this is in regards to that. So let me just put this into the record that the board of directors received the email from the property management that was sent to us by Karen Hill, and I'm just going to read that into the record. In regards to the emails stated that once they received the violations, that the fee being imposed for what appears to be a minor trash violation is excessive and deeply concerning. Penalties of this nature creates unnecessary hostility between the association and residents, and in my opinion, are disproportionately to the alleged violation itself. The association should carefully reconsider whether this level of enforcement is reasonable and appropriate due to the circumstances. So the response from the board of directors was that that we received your correspondence in regards to this bulk trash violation. So on Wednesday, April 15th, 2026, your tenant placed a non-bulk item, pots and pans, contained within a box in violation of our waste disposal policy. Trash disposal vendors do not remove boxes and pots and pans, resulting in their removal by our maintenance personnel on Monday, April 20th, 2026. The item remains in violation for 5 consecutive days. The weekly email and signs posted on the door clearly state items that do not fit in the compactor. The pots and pans and box your tenant placed into the bulk area will not be removed by the service provider, as it does not meet the criteria for removal of bulk items. Bulk items are considered mattresses, bed frames, refrigerators, dressers, dishwashers, dryers, and chairs, which are considered bulk items. Royal Green's declaration, bylaws, and Florida statutes, specifically 718.303, govern fines and hearings related to the condominiums. The association may levy reasonable fines for the failure of an owner of a unit or occupant, leasee, or invitee to comply with any provisions of the declaration, the association bylaws, or reasonable rules of association. A fine may not become a lien against a unit, and when it comes to condos. A fine may be levied on the basis of each day of a continuing violation, with a single notice and an opportunity for a hearing. However, the fine may not exceed $100 per day, or the operative part is $1,000 in aggregate. I would like to draw your attention to the Florida statutes, and our declaration does not provide for a 7-day cure. It is a courtesy. While we sympathize with you and your tenant's perspective, it is imperative that you abide by the rules in place by Florida law and the governing documents. With that being said, you could have received a fine for $500 for $100 per day. And also, this is your tenant third violation with regards to bulk trash violations. It is your responsibility to keep yourself acquainted with the rules and regulations governing the property to ensure that we have the community standards. So I also said that you have two options. You can either pay the fine for $150, or you can refute the violation at the scheduled hearing, which we have before us. Again, the fine was only for $150. We could have made it for $500, but we chose to leave it there because we know it's kind of hard. But this is the community standards that we all live up to in this community as owners and tenants. And I can see if it was a issue that they did not know about this, but they knew about that. And if they had any question about pots and pans being placed in there, they could have reached out to the property manager. But as I stated before, on the signs it says absolutely no boxes, period. So that's all that the association in regards to the violation has right now. Ms. Hilt, you can go ahead and refute the allegations here.
Ms. Hill,
I'm not hearing anything. You may be on mute.
she's on mute. Ms. Hill, you would have to unmute yourself. I'm not sure if they're having technical difficulties, but Miss Karen Hill,
I see her in the she's still here, and maybe she can be calling you or something and let us know if she wasn't ready for the hearing.
I don't receive any notifications, so I'm not.
All right, well, did she receive 14-day notice regarding this violation? Yes.
Yes, she did.
Yes, I read the email into record, and that's what she chose to do, is to be at this meeting. We are all here.
Okay.
We all took the time out. Ms. Hilt, going once, going twice.
Committee, make a motion for 21 days reserve.
I will make that motion for the 21 days.
Thank you.
Second.
Can I get a second? Thank you so much.
Second.
Thank you. Okay.
All right, we have
Right.
another. We have another one, 1211. Do we have anyone there present for 1211?
We have no one on site and no one online.
Okay, so I'm just going to present the case right here regarding this. This is a violation for bulk trash. Excuse me, for hitting the arm bar. Roxanne, can you just play the video? I think the video will say it more than what I can explain.
Sure. Can everyone see my screen?
Yes.
Yeah, you just got to back it up a little.
For some reason, when it was exported, it exported way before the time. Let's see if I can get the other video. Just give me one moment.
So this is in regards to for the damage to the arm bar. We did obtain the access from our access records, and it coincide with the plate which is registered to the owner's tenant in that same unit, and to verify that, and as you can see the picture, the truck had entered into there, and the arm bar came down. We didn't receive any other information regarding this, an email from the owner or the tenant. There was no dialogue back and forth, and we sent it to the hearing, and that's where we at right now. And Roxana, you got the video yet?
Are you able to see my screen?
Yeah, I see it.
I see it. I just don't see, I'm not sure what I'm looking at. I just see a truck going through the gate.
Okay, let me see if I'm able to edit this bookmark because for some reason it's not starting from the beginning.
Yeah, go to the time and date on the actual and let it run from there. Or you can go into it and you can edit. You can go into edit and spread it.
It keeps jumping. This is weird. Let me see if we can go from
Yeah.
here.
Yeah, now click edit and then spread it out.
Yeah, it's not. It's loading.
It's loading.
It's loading, but it's not. It just continues to show that same spot.
So you probably have to go to that time and date and just play it. Yeah, come out of the come out of that the clips and go directly to the front gate and go to that time and date.
Was 5/6.
Yeah, it's gonna be a 5/6, yeah, at 18:06.
Mm-hmm. Oh, it's because it's past 30 days. It's not gonna let me play. Yeah, that's the only section we're able to get because it's past 30 days.
Okay, can you replay it again so they can see where the arm bar was striked? Maybe she should save the videos. That you Yeah, it should be able to keep playing, right? And show the arm falls off after it struck it. Roxanne, I think this is gonna have to pull the video back up and send it to the committee so they can make their decision on that one.
Okay. No problem. Okay.
All right, you gonna make your motion?
Yeah, committee motion for 21 days reserved.
I make a motion for 21 days, assuming we get the video showing the damage. From what I've seen, I didn't see any damage. So I don't know if it's just because it's slow coming through on my phone or. But
We'll send the video.
Okay.
We'll be able to send.
Yeah. Okay. Thank you.
Second,
No problem. Thank you. All motions carried. That's all we have for today, committee. So I'm going to make a motion. It is now 3:52 to adjourn the meeting.
I'll second.
All in favor?
aye.
All right, this concludes the meeting. Committee, stand by for a second. This concludes the meeting.
Thank you, everyone.
You're welcome.
Mr. Gambino, the meeting is over.
Yeah, he's leaving. Thank you.
Thank you. Do you send the meeting minutes out over email or do I have to?
The meeting minutes will be on the website once they're completed, the meeting minutes draft.
Okay, and then when is that usually come from the website?
Within the next few days or so. Yep.
Roxanne, you want to close that door for a sec?
Yeah, give me 1 second.
Okay.
Gerard, can you hear me?
One moment.
Yes, 1 second, 1 second.
Okay.